Hi everyone, and welcome to another episode of Vienna Arbitration Talks. Today I'm really happy to host one of Germany's most distinguished arbitration experts and brightest legal minds, Professor Klaus Sachs. Hi Klaus, welcome to Vienna Arbitration Talks.
Hi Peter, hi.
Klaus, how have you been spending these strange times? I mean, we are all kind of trapped at home mostly, and no travel, no hearings in person, I would imagine as well. How have you been doing this?
Well, I've had only one hearing in person, mind you, in January. We had to go to Berlin. It was a domestic case. It's a case against the government in which I act as counsel. And the arbitrators insisted that we have a hearing in person. And so we went to Berlin and had to be tested. But that was the absolute exception. All my other hearings have been postponed in the first phase and then held online. And the experience shows, and I think all of us who have had this experience show that the experience shows that it works quite well. The technique has been developed and it works fine. I see cases where counsel are reluctant to do it online because they think that the witnesses are very important and cross-examination is needed in person. So in particular in cases where, for example, corruption is on the table, we had cases where we decided to postpone, but we postponed now in one case for the second time to November. So we will see whether in November we will have an in-person hearing. But the rule is on. Yes.
Mm-hmm. And how was that hearing that you actually had in person with I guess there are some strict measures that have to be undertaken. I don't know. You said you all did the testing.
Yes, we were all tested. That was the condition. And it was a midstream conference, the subject of our talk today, because it was a German arbitration. And so it lasted for 6 hours. Only the advocates on both sides were present and the tribunal. And the other representatives of the parties were linked to the hearing by video. Mm-hmm. And there was no witness testimony and no expert testimony.
Mm-hmm. Well, Klaus, let me introduce you to our viewers very shortly. Dear viewers, Klaus is a partner at CMS Germany, and as I've said before, he's one of Germany's most distinguished experts for national and international arbitration, with more than 25 years of experience as counsel and arbitrator in more than 250 arbitrations, and plenty of those are major investor state arbitrations. Klaus is currently a member of the ICA governing board, and he's also sitting on the board of the German Institution of Arbitration, the DIS. In the past, he used to be a board member of the Swiss Arbitration Association, the ASA, vice president of the ICC Court, and vice president of the LCIA. And as far as I have just realized now, he is also on the Formula One Contract Recognition Board, which sounds like a very interesting function. Klaus, can you tell us something about this Formula One Contract Recognition Board?
This is what I thought when I was approached whether I would accept to sit there. I must confess I've had no case so far, and also the three other colleagues. We have four, from which when there's a case, three of us will be picked to adjudicate. Mm-hmm. But so far I haven't had a single case.
Well, it's Formula One. People don't like disputes, I guess. Very peaceful.
Yes, and my friends and colleagues who know me and who know that I'm a rather prudent driver, they think it's a bit funny that I sit on this board.
It is. What I haven't mentioned yet before is, Klaus, you were a mentor to our group in the Young ICA Mentorship program, where I was a buddy to 4 bright young mentees. And by the way, dear mentees, if you're watching this now, hi to all 4 of you. But Klaus, you've served as a mentor in the program for a while already, and you've supported a lot of young practitioners in the program. So what is your experience with the program? Can you tell us more about this? How does it work? How is it to be the mentor?
Well,
What do you have to do?
I think it's a brilliant idea. It's a brilliant idea because it brings together practitioners with a certain experience and young practitioners who strive at becoming part of the scene and to develop into a arbitration practice as counsel or later as arbitrator. So it's a very good platform to exchange views, to discuss issues. The format normally is that you invite the mentees to agree on a subject, on a topic to be discussed at the next session, and then they prepare a paper, and then they orally present their ideas, and then we have a discussion, and they learn from those debates. I learn from these debates because some contributions are really good. And
I also learned from those debates, I have to say.
It's a two-way street. It is not so that even as an old fox that you don't learn things. I mean, it's
true.
like teaching at the university. I mean, it's always challenging and enriching, I must say, and I like that. And I'm now in my second round. I have a new group of mentees, and also this new group is very talented, and it's very enjoyable. I take this serious, and I know that many of my colleagues from the governing board are rather enthusiastic too, and so I like it. I think it's a very good program. And to my former mentees, I say hello if they are watching this, and it was very enjoyable to work with you.
Thank you, Klaus. Let's move on to our topic for today, the Midstream Conferences. And I wanted to clarify for our viewers first, by this I mean a conference that takes place somewhere between the main rounds of submissions, where the tribunal would discuss substantive issues with the parties. So not just a procedure conference like we are used to, like we do all the time, but we would discuss substantive issues. So, and I think it goes well to addresses the issues of, like, we hear these criticisms of boilerplate arbitrations where first the tribunal establishes the timeline, then the parties exchange their submission, then there's maybe a document production exercise or not. We have another round of submissions maybe, and only then, right before the hearing, maybe 2 or 3 years down the line, the tribunal starts looking into the substance of the parties' arguments, and that can be an issue, right? So, Klaus, I would imagine at least some of these issues would be resolved or by organizing a midstream conference. So, what do you think? What are the main advantages of such conferences? How do these conferences look like?
Well, let me say, one of the fundamental problems, I think, of this type of boilerplate arbitration is that there is not enough interaction between the arbitral tribunal and the parties during the first long phase of the proceedings. And by that I mean the time period between the first session or the terms of reference conference, the case management conference, and the main hearing. We all know that this time span today is about at least 18 months. And during all this time, there is no interaction between the tribunal and the parties on the case, except for the document production phase, or except for interim measures or other applications, but not as regards the substance of the case. And then after 18 months or 24 months, you sit together in a hearing, and for the first time, the parties jointly act on the substance of the case. And it seems to me that this is not a very efficient system, and this is why users complain increasingly about the increasing cost and the long time that arbitration procedures take. And I think our community must reflect whether this cannot be improved. And I think one of the techniques that could be considered is the technique of introducing a midstream conference. And by that, I mean, and those who advocate such conferences mean, a first session with the parties after the first exchange of their briefs, meaning the statement of claim and the statement of defense. Because by then the parties have presented their case in a substantial way, in a comprehensive way. They put on the table what they have as evidence, witness statements, documents, expert opinions, etc. So that is their first shot, but it's a substantial shot. This is what they have. Of course, they hope to get more by the production of document, but that's a good start. And as an arbitrator, of course, you are, in any event, your mission is to study those statements, and so you have an idea about the case. You may have already exchanged views with your colleagues, and so it is not that you are completely unaware of the issues, and you must be, for example, at the latest when it comes to the document production phase, because then you need to know the file in order to make a meaningful decision on the respective requests. So the idea was to have such a first session, to get together and to discuss the case in its substance. Now, there are different formulas to do that. And let me also explain, such a technique is very common, and it's part of the tradition in certain jurisdictions, such as mine, in Germany, but also in Switzerland, and in Austria, and in Japan. So in some civil law jurisdictions, that is a tradition. And interestingly, Neil Kaplan, a very prominent UK arbitrator and former judge, he advocates the so-called Kaplan opening, which essentially provides for the same technique, namely to have a first midstream conference or hearing, during which the parties plead their case and during which the tribunal then starts discussing certain issues, raises questions, give hints. So even though the approach is a bit different, it is very interesting to see that this is a feature that is common to both legal traditions, but rarely used. And my pleading is to think about this technique more often and to use it, because my experience is it's a very good tool.
And I was just wondering, you mentioned before this exact midstream conference that you had attended in Berlin. I mean, is that a very common thing in German domestic arbitration then?
Yes, it is. I mean, just to give you, to show you how it works, in Germany, this is not the model I'm proposing for international arbitration, but because it is rather extreme, and some people may be shocked to hear that. But I mean, the tribunal was extremely well prepared. They had prepared a decision tree, leaving the options of the various forks in the road open, but clearly showing that they had understood the case. They went through the decision tree with us. They asked us questions, which sometimes were critical to one side, and other times they were critical to the other side. So they left it open that by putting the questions, both sides became very aware of, the thinking of the arbitral tribunal and of what they should develop in the further submission. So that to hold such a conference also corresponds to the expectation of parties coming from our jurisdiction. And that's the issue, because where you do not have this tradition, parties have a different expectation because they don't know about it, and in particular counsel have a different expectation because they're not used to it. So it is something that needs to be introduced into the system with conviction. And I think in that regard, parties are also important because experience shows that when parties are present in such midstream conferences, they appreciate it because they like to know how the arbitrators approach the case, how they view things, how they ask questions. What we often hear from parties is that, well, we've been in these proceedings now for 2 years. We've never seen those arbitrators. Now we see them for the first time in the main hearing, and they don't say a word. They just say there, listen, give procedural instructions. At the end, they raise 2 or 3 questions, and that's it. So, there are extremes. I mean, I've been in cases where the arbitrators were so silent that the client at the end said, well, what's this? Is this arbitration?
Well, I guess if they're silent, there is less chances of them getting a challenge. I don't know if they are silent.
Well, yes, but there's also this paranoia of being challenged,
Right.
It's, we must be a bit robust, to deal with that.
You just mentioned, I'm sorry, you mentioned the cost factor maybe over here. I would imagine that it does cost a bit more if you meet in person or whatever. It's basically like organizing a mini hearing maybe.
Right.
But I would imagine that there is also some advantages to the procedural efficiency, and that obviously means the cost of the proceedings in the end, no?
Right. I mean, that's the criticism we often hear. This would increase the costs, and it's waste of time and money, and it will only prolong the proceedings. Yes, it will create additional costs because counsel has to prepare, the arbitrators have to prepare. You have at least 1 day of hearing, plus if it's a physical hearing, travel costs, etc., etc. But the benefit is that we reduce costs thereafter because the second round of submissions, they will become more focused. And also the taking of the evidence will become more focused at the main hearing. So you always have to balance the inconvenience with the benefits. And I think it's clear that the benefits here outweigh the disadvantages.
I was wondering, how would such a conference look like? How does it begin? Would you have maybe already opening statements by counsel, like in an actual hearing, and then I don't know, responses to this? How does it work? I've never seen one.
Well, I mean, there are different formats, obviously, but I think that a very good formula is indeed the one suggested by Neil Kaplan, namely to start with pleadings. Each side has an opening, a second round of short rebuttals, and then in a second phase, an exchange between the tribunal and the parties, meaning that the tribunal then asks questions, addresses issues, asks and gives the parties hints as to what issues need to be developed and where the tribunal sees issues. Of course, you must be careful in this exercise because obviously you should not, for example, mention a legal argument that has not been raised by the parties, or another aspect which maybe one or the two parties have overlooked that could play a role. I mean, here it becomes a little bit difficult. But otherwise, if an issue has been addressed, I think it is absolutely reasonable to talk about it, to see whether the tribunal has well understood the party's position, seeks whether there's common ground to be found between the parties so as to narrow down the issues. And when it comes to expert testimony, the experience shows that also in this regard, the Midstream Conference may be very helpful because, as we all know, experts, party-appointed experts, are instructed by their party. So they get instructions. And it may turn out that those instructions are not the relevant ones because at the end of the day, the tribunal will find that the experts should assume other facts or prerequisites. And so at such an early stage, midstream conference, one could, for example, if the tribunal thinks, well, those instructions maybe are not the ones that will ultimately be the relevant ones, they could at least say, would you please base your expert opinion on the following alternative assumptions without any prejudice, but just assume that the relevant date is not the 1st of January, but the 1st of July. Would you please recalculate, etc.? Or please assume that this and this regulation does not apply in the field of technical issues, for example. What would be your expert opinion then? So I think that could be helpful too, because then at the hearing, you will by then have the expert opinions based on what probably will turn out to be the correct assumptions. And so you will advance the proceedings and therefore have the benefit when you hear the experts during the main hearing that you're better prepared and you can pose better questions to the experts and form a better view on their findings. The other criticism that we hear is, well, this needs to be well prepared and additional work for the arbitrators, etc., etc. Yes, but I mean, the arbitrators have to study the file in any event, and the work they will have spent to prepare the Midstream Conference will be beneficial to their preparation also for the main hearing, because at least at that time they have to be well prepared, so you can advance that. And so those criticisms, I hear them, but I think ultimately they're not so convincing as yeah.
I was wondering the Midstream Conference would probably be a good time to invite the parties to address further issues, maybe that the tribunal would consider important, that in the tribunal's view have maybe not been discussed as much as the tribunal would wish to. I actually did that once upon your advice, so that was another advantage of participating in the Young Inca mentorship program. It was in a normal case management conference in one of my arbitrator cases, and in my view, I thought that the applicable law question was was a very, very relevant one, but the parties kind of left it aside a little bit, so I wanted them to plead a little bit more on this issue. What's your opinion on this?
Well, as I said, you have to be a bit careful. I mean,
yes.
In civil law jurisdictions, we have the principle jura novit curia. But that principle is not recognized globally. So you have to be a bit careful. I think when it comes to very basic features such as the applicable law, and tribunal should intervene. I had a case where the parties pleaded on the Italian civil law on sales, and it was clear that the Vienna Convention would apply to that sales contract, but neither party has, raised this issue, and they pleaded under Italian law. So we said, well, look, I mean, please reconsider your positions, but we think you must apply the Vienna Convention on the international sales for this case. And they were kind of surprised because They had not thought about it, but we felt it would not, serve justice if we were to render an award on a law that clearly was not applicable.
Mm-hmm. How about the opposite situation? A tribunal could potentially tell the parties, if the parties are bringing heaps of evidence, expert reports, witnesses, on an issue that the tribunal at that time finds less relevant. I mean, that is a little bit more tricky, I would imagine. Would it be in the interest of the procedural efficiency for the tribunal to let the parties know that this is not something it considers that relevant, so that they don't spend more efforts and more time and more costs on this particular issue?
That is difficult. I think we should, as a rule, not say at such an early stage, you can forget this. This will not be relevant. But you can, if you think that it will probably not be relevant, you can make the parties understand that, you have doubts as to whether it is relevant. They still need to convince the tribunal that it is, and they get the opportunity to do so. But you can express skepticism. I think that would not go too far, because ultimately all is about convincing the tribunal. And I think for a party, it is better to know that the tribunal is not yet convinced by an argument than to be, left in the dark. And also for party representatives who are present at such meetings, they get a better feeling for, the chances of success of their case. So far, they have only spoken to their lawyers, and some lawyers have the tendency not always to, maybe they have the tendency to present the case a bit too optimistically, and so that also helps. I once heard the comment of a very experienced colleague who said, well, we suggested such a conference to our client and to the tribunal. And he told me later on, yes, we did it because we knew that our case was not extremely strong, but our client just didn't believe it. And so we thought it would be useful to have such a conference to show our client that, there were certain issues. So they used this detour, if I may say so, in order to enlighten their client.
So I can imagine also maybe the parties, the clients, the users of arbitration may be more willing to think of the settlements or any, if they see a little bit how the tribunal is thinking already at that stage.
Yes, that is another aspect. If there's, settlement always requires, willingness to settle. But if there is some hope and some interest in, getting this resolved by settlement, then I think it's a very helpful tool. I mean, the techniques of mini trial internally, etc., or even where parties try to explore the chances, etc. So this, in a way, is a similar exercise. I mean, where do we stand? Do we have a real chance to win with this argument? Is there a risk that we have maybe underestimated, etc.?
How about preliminary views? I would imagine it would be a good time to share preliminary views with the parties, but of course, would you ask them for consent before that? Or how does that work? Would you wait for them to ask you? Would you offer preliminary views? Of course, based on their consent.
Well, I mean, this is probably the hottest topic in that exercise and the most difficult one. In our jurisdictional tradition, it is the rule that the judge clearly gives his preliminary view on the factual and legal issues. In Zurich, you have the tradition that at the Handelsgericht that the judge presents a votum, that's to say, a decision draft based on what he has or she has read in the files and studied, and tells the parties, well, this is where I stand, this is probably what I will render as a decision. Do you still have something to say? Or do you want to settle? So this is extreme, and I think would not be accepted by the common law community, maybe by an individual, but not by the community. So that's the extreme. On the other hand, if the parties so request to get a preliminary review, I think there's nothing under the applicable arbitration laws of all major jurisdictions or under the rules of all major institutions that would prohibit the arbitrators to do that. In most rules, you find at least some provisions that invite the tribunal to actively conduct the proceedings and to give, to indicate issues that should be dealt with, etc. So the most outspoken rules are the new DIS rules 2018, which invite the tribunal exactly to do this exercise. But obviously it needs the consent of the parties. And if the parties consent, then again, you should be cautious. I mean, you could say on a preliminary basis, we think that the relevant date for this and that is the 1st of January because of this and that. We are aware of the counter arguments that and that, but so far we are not convinced. We think it's a matter of burden of proof, and we are inclined to think that the burden of proof lies with the respondent. You will have the opportunity to convince us of the contrary respondent in your further submissions, but please be aware that for the time being, we would think that it follows from there, that, etc., etc. So you could do that with all, with the precaution that you have to take, meaning that you should ask the parties to confirm for the record that by expressing such preliminary views, they also inviting you to express such preliminary views, they waive the right to challenge you or later the award. So you have to take these precautions, and then you go. Obviously, it also requires the tribunal to have thought about the issues beforehand, because you are three as a rule, and you have to agree.
Deliberate already.
Yes, if you are not in complete agreement, you could say, well, we haven't made our mind up, but one could say that. On the other, you can leave it open. So, but my experience as counsel is that I would, as a rule, I would be grateful to hear such preliminary views in order to be in a position to refine my argument for the hearing.
In the second round, exactly, or for the hearing, exactly. So let's hope that this gets a little bit more. I mean, you said in domestic arbitrations in Germany, it is quite common. I have heard of arbitrations that people are starting to do these kind of things. So I think it's a very interesting topic, and it's also an interesting way to streamline the proceedings to make it more efficient, to focus on the things that will be then considered by the tribunal, rather because in other cases we are always focusing on procedural things that we could change to make it more efficient. So thank you so much, Klaus. It's been a pleasure. It's always nice to see you. Thanks for joining us. I really hope to see you in person this year.
So
it's not that far, Munich, Vienna.
Thank you, and stay well and safe, and hope to see you, sometime to see you. Thank you.
Thank you so much. All best wishes to Munich. And the same to you, dear viewers. Best wishes to wherever you are. Thanks for watching another episode of Vienna Arbitration Talks. Don't forget to watch us next time. But in the meantime, greetings from Vienna, and stay safe.